The next paper will be presented by Sam Ewer. Sam was also on Green's list, has been at the bar. I was going to say recently at the bar, but everything's recent if you've been here as long as I have. Sam comes to us from Adelaide University via Alan's Arthur Robbs, and like the previous speaker, Tiphanie, was catapulted into the nearest part of the centre of the cosmos because he was the associate to President Maxwell, the President of the Court of Appeal, which is one place to start in Melbourne and see how it all works. He also practices extensively in commercial and administrative law and has appeared for the state government in matters involving the Charter of Human Rights and Responsibilities Act. I call on Sam to deliver his paper.
Thanks, Tom. Well, I'm to look at the second part of this presentation, which is to consider a little more closely the nature of an appeal on a question of law and what that entails and what the consequences of that are, and second, what a question of law is and how to distinguish a question of law from a question of fact, a deceptively difficult question to answer. So first, what's the nature of an appeal on a question of law? I like to think of the requirement that you show a question of law as both a filter and a foundation for appeals from VCAT and the AAT. It's a filter in this sense, a rather obvious sense that you don't get to have an appeal on a question of fact. And that knocks out a substantial number of potential appeals, or at least that's Parliament's assumption. And it's a foundation in this sense that without a question of law you don't have an appeal. There's no jurisdiction in the Supreme Court or the Federal Court for either of those courts to hear your appeal. So it comes back to what Tiphanie just mentioned, which is that unless you express your question of law as a pure question of law, you may find yourself with a proceeding that lacks any jurisdiction at all and is liable therefore to be dismissed, which is a considerable setback for your client. The filter aspect of these words, question of law, also, as Tiphanie hinted at, reflect what you might call orthodoxy in administrative law and constitutional law in Australia, and that is that courts stay away from decision-making areas which Parliament has given to tribunals and administrative decision-makers with the view that that's really their area. And there is that sort of view that decision-makers have been given power by Parliament to determine the facts, whether they get them right or wrong, without interference from courts, and that courts' roles are to ensure that whatever decision is reached in a way that's lawful. The result for these appeal jurisdictions, the Section 44 jurisdiction and the 148 jurisdiction, is that you find legislative provisions expressed as conferring courts relatively wide powers, but they're powers that courts have perhaps instinctively interpreted very sparely and used very sparingly. The first example of those, and there are three, is in the context of the relief that you get on an appeal. It's pretty trite to observe that if you succeed in an administrative law appeal, you get sent back to the decision maker who originally made the decision. But if you break up the relief that you get into its constituent elements, what you're really getting is an order, firstly, to set aside the decision below, what would be called in the prerogative writ language certiorari, or quashing, and second, an order to remit the matter to the tribunal below, or what would have been called mandamus in prerogative writ language. So the first of those two orders, the setting aside order, would seem to follow whenever you establish that there was an error of law made in the tribunal below, and that error of law had the capacity to affect the result. In other words, it's not enough to show that there was an error of law if that error was, on no view, able to affect the result. But it's helpful to remember that the standard of the connection between the error and the result doesn't necessarily need to be demonstrated to be causative. It only needs to be shown that the error had the capacity to affect the result, not that it in fact did. And that principle seems to come from the High Court's decision in Australian Broadcasting Tribunal and Bond, to which you're referred in the paper. There has been in Victoria the use of language of vitiating errors and determining whether an error is or isn't a vitiating error. It's my view that Bond largely should put that language to bed, or at least make it clear to practitioners that to vitiate a decision, an error only needs to be able to be demonstrated to be capable of affecting the outcome. So much for setting aside orders. The second order is a remitter order, and as I've already said, that's by far the most common outcome once you've got over the hurdle that the decision below should be set aside. It's consistent, I should add, with this view of the world and the view of the separation of powers that says courts should leave it to tribunals to do their work. I should, as an aside, mention here that, as sometimes happens in appeals, the parties decide that they want to resolve the appeal and have the matter sent straight back to the tribunal for rehearing. Happened in an appeal I was in not so long ago. The respondent usually takes the view, well, yes, we accept that there was an error below, we might as well get on with having a second hearing. In those circumstances, you need not only a set of consent orders, but also a memorandum to the court explaining where, in your joint views, that is, in the views of both parties, there was an error, in order to satisfy the court that it should exercise the power to remit. It's a jurisdictional issue for the court. So just having a look at these provisions in your handout, you'll see that Section 44, subsection 4, right at the top of the second page, permits the federal court on an appeal to make such order as it thinks appropriate. That would seem to admit the possibility of orders other than only remitter. And then if you look at the equivalent provision for the VCAT Act, that's subsection 7 of 148, you see it's even broader. It seems to invite the court to make one of 4 possible orders, but specifically 7 subparagraph B, in order that the tribunal could have made in the proceeding, or subparagraph D, any other order the court thinks appropriate. Now, reading those 2 provisions, and in particular the VCAT Act provision, it's tempting to think that that's an invitation by Parliament to courts to make orders other than a straight remitter order, perhaps to facilitate speedy resolution of appeals of this kind. Well, we have some learning from the High Court about that after its decision, its second decision in Osland and the Secretary to the Department of Justice. That, you might remember, is the case involving Heather Osland, a woman who was convicted of, now I don't remember whether it was murder or manslaughter, for killing her husband, and was later petitioned the Governor and Council for mercy on the basis that she suffered battered women's syndrome. The Attorney General dealt with the petition for mercy by asking three eminent silks, or a number of eminent silks, to give an advice as to whether the petition ought be granted, and received that advice over a period of time, a number of different memoranda, and when making the decision to refuse the petition of mercy, issued a media release that said, "I've taken advice." And privilege scholars will immediately identify that that could constitute a waiver of privilege. That was the issue decided by VCAT and subsequently by the Court of Appeal first time round. The proceeding began in VCAT as an FOI application and brought by Mrs. Osland seeking access to those advices. One of the issues in the FOI proceeding was whether there were differences, material differences between what one advice said and what the other advices had said. And that was relied on as a basis for the submission that the public interest override in the FOI Act should be invoked or should be relied upon to order access to those advices. The public interest override says that the Tribunal should grant access to any document, including a privileged document, where the public interest requires that access be granted. It's a very subjective decision and that's left for the Tribunal. Well, the Court of Appeal said no, there wasn't a waiver of privilege, first of all, and second, the public interest override shouldn't be invoked in this kind of case. It's just not a case where the public interest override was capable of giving you the result that the document should be released. That went on appeal to the High Court for the first time, and the High Court said, yes, we agree with you on privilege, but the Court of Appeal, what you should have done is look at the advices and answer whether the advices should or do bear upon the question whether there's material differences between them, and then a further question whether the public interest override should be applied to release those documents. The Court of Appeal took the case back from the High Court and said, well, we've looked at the documents and we still think that the nature of these documents could never mean that the public interest override could be applied in this case. They went back to the High Court and the High Court said, no, what we asked you to do was to look at the documents and then decide whether there was the basis found in these material differences that were alleged for an argument that the public interest override should be applied. And if there was, to then send it back down to the Tribunal for the Tribunal to decide that question. In other words, the appropriate place for that judgment call to be made about whether the public interest compelled production of documents was the Tribunal who had originally been granted the statutory power to make that decision. And so that was the order of the High Court. However, by this stage, both the Court of Appeal and the High Court had looked at the documents, and it was in fact the High Court that decided, upon the basis of its own review of the documents, that the matter should end here, 7 years down the track from its commencement, and that after all, the document should be released and Justice Morris's decision in VCAT upheld. That's a long way of saying that in general, what the High Court referred to as substitutive orders, or the kind of orders that seem to be contemplated by Section 147, subsection 4, should really only be made when one conclusion is open on the correct application of the law to the facts as found by the tribunal. Otherwise, the question of law appeal begins to descend into the possibility that it's used as a rehearing of the substance of the appeal. I can think of a couple of examples of cases where a court on appeal might properly decide to substitute its own view, apart from Osland. The first may be where a tribunal has proceeded on an improper assumption that it had jurisdiction. In those circumstances, of course, there wouldn't be a basis for sending a matter back to the tribunal. And the second is the situation that sometimes occurs where the tribunal says, well, I think the state of the law is this, but if I'm wrong about that, I would find X, Y, Z. And in those circumstances, it might be open to the court to say, okay, well, X, Y, Z applies because the tribunal was indeed wrong. And there are cases as well, one is cited in the paper, where only part of a matter gets remitted back to the tribunal. For example, in a case about veterans' entitlements, the quantum might be in dispute, but the liability to pay pension might not. There is the final issue of when a remitter order is made, whether the court should direct the tribunal be constituted by the same member as heard the first matter in the tribunal, or a different member, and there can be scraps about that. You'll see that subparagraph 8 of 148 raises the issue. In fact, it requires the Supreme Court to make a call as to whether it should go back to the same member or a different member. And there are cases that go each way. The general guidance seems to be that wherever you've got a member below who's made adverse findings of fact against a party, you've got an uphill battle. You've got a more difficult uphill battle where the determination depends upon credit findings about witnesses, and you've got, I would have thought, an impossible case where there's an allegation made out that the tribunal member was biased. On the other hand of the equation, you might satisfy a court that it should send the matter back to the same tribunal, perhaps where the resolution of the case involved the tribunal looking at a large volume of documents or familiarising itself with some complex or technical provisions. An FOI case might be an example of that. The next issue is that there appears to be an invitation in these provisions to courts to make findings of fact. It's certainly open to courts to receive fresh evidence and make findings of fact. But once again, the orthodoxy prevails in the application of these powers, and it's in a very rare case indeed where a court exercising jurisdiction on one of these two appeals admits fresh evidence. And by fresh evidence, I really mean evidence about the substantive issue that was before the tribunal. Of course, where you are running a case that depends upon establishing facts about the way the case ran before the tribunal, then you need evidence of that. And that's where the affidavit that Tiphanie mentioned gets filed with Supreme Court applications comes into its own. You would, for instance, exhibit in a case where you allege bias the transcript of the hearing below to your affidavit in order to have the material before the court to make out your allegation of bias. And similarly, if you were alleging denial of natural justice below, you'd need that material as well. And you may need correspondence between the tribunal or between the parties for that too. And finally, relating to the nature of a question of law, the courts take a very orthodox approach to the reading of tribunals' reasons, and there's the warning expressed time and again, look, we don't want to be too pernickety when we read Tribunal's reasons. In this case of Pozolanic, which is cited in the paper, the full court of the Federal Court says we don't want to be concerned with looseness of language or unhappy phrasing. And this is really the respondent lawyer's persistent refrain, or you're just reading too much into the reasons, or that's not what the decision maker meant. Ultimately, that's the task for the applicant or appellant, that is convincing or persuading a court to see the reasons or to read the reasons the way you read them. I'll move now to the distinction between a question of law and a question of fact. The first an important qualification to make is that it's in many categories not a sharply drawn distinction. In the paper, we've put together a little table that breaks down some of the categories of questions of law that might be raised on appeal. And if you cast your eye down the list, you'll see familiar grounds, at least grounds familiar to admin lawyers. Most of the usual suspects, in fact all of the usual suspects are there. So very often the question whether a question you raise in your notice of appeal is properly a question of law or whether it's in fact a question of fact can come down to argument. Sometimes it's just a matter of persuasion. The other thing to note about the list before we launch into them is that these categories inevitably overlap, and where you have a complaint about the way a tribunal's dealt with your case, it's important to think about which of these categories it sits most comfortably in order to make your appeal most persuasive. Well, the first category of error in the table is errors relating to fact-finding, and it's funny having to discuss how a fact-finding error could be an error of law, because it simply doesn't seem to be the kind that could. There's the analogy of a jelly and a jelly mould that I like to use for this. If the tribunal's task is to determine whether the jelly fits the mould, then the question what shape the jelly is the question of fact, and the question what shape the mould is a question of law. But of course, they're really the same question if you, depending on how you look at them. So courts have had to struggle with how to distinguish between whether their task is working out what the shape the mould is or working out what shape the jelly is. And you have in the second row of that table a distinction between a case where facts fully found fall within a statutory provision involving very simple words permitting only of one ordinary meaning, which it's accepted is a question of fact, and the other issue where the facts fully found fall within the provisions of a statutory enactment properly construed, which it's accepted is a question of law. Now that right-hand category would appear also to fit beneath in the category of issues concerning construction of statutes. So it's very simple to, or it may be more simple, I should say, to answer a simple question like whether conduct is offensive, or whether a jelly is orange in colour, or whether, as the Federal Court recently had to ask itself, whether a toasted mini ciabatta was bread or a cracker. That was a GST case. If it was bread, no GST was payable. If it was a cracker, GST was payable. And there's a very interesting 111 paragraph analysis of that question that Justice Sundberg drafted, including reference to expert evidence and recipes, cell structure of the product. He ended up, by the way, coming down on the side of cracker in that case. But that's an example of a factual determination that seems very squarely to fit within the realm of fact and be reasonably unassailable, at least in terms of that analysis. On the other hand, a more complicated statutory regime, or a regime that can apply to many different varied types of factual scenarios, such as the question when the public interest requires a document to be released, is an example of a statutory provision that probably needs a little bit of construction before you're able to fit it over a set of facts. The second category listed in that table is a category concerned with construction of statutes, and it shouldn't be surprising to read that the meaning of a technical term in a statute is a question of law. However, you should note that where a word can be said to be used in its ordinary non-technical sense, then that meaning is a question of fact. The next category of error is the category that is familiar, that is relevant and irrelevant considerations. Clearly, a tribunal will exceed its jurisdiction if it takes into account a relevant consideration, and will fail to exercise its statutory task if it doesn't take into consideration a relevant consideration. Next category is procedural errors, and there have been some suggestions that whether a tribunal accorded procedural fairness to a party may not constitute an error of law. It really is a matter that is to be established on the facts. However, in recent times, the concept of, well, there are two answers to that. Firstly, the statute establishing these two tribunals, the AAT and VCAT, usually can be construed to find that it requires those two tribunals to accord procedural fairness in the course of adjudicating disputes, and therefore a breach of the obligation of procedural fairness would amount to a failure to exercise jurisdiction. And the second thing to observe is that all of these categories of error would, under contemporary administrative law principles, constitute jurisdictional error, or could be characterised as jurisdictional error. The next category is the category of bias, and again, bias almost certainly, if proven, you've got a bit of a task on your hands establishing that there was ostensible bias, and an even more difficult task establishing actual bias. But that almost certainly is a jurisdictional error and a basis for establishing an error of law. The question whether reasons are adequate is, and whether that constitutes a question of law, is somewhat vexed. It can be said, at least for these two decision-making bodies, the AAT and VCAT, that they're both required by their statutes to give reasons. The question is what standard of reasons courts should expect from the tribunals, and in particular, what standard of reasons should be expected from tribunals in jurisdictions where there's a high volume of work and a high turnover. I'm thinking in particular of the residential tenancies list at VCAT, where matters are pumped through many every day. it wouldn't be an easy task convincing a court that reasonably summary reasons given by a tribunal in support of its decision in the residential tenancies list should be scrutinised closely for the purposes of establishing error. I think courts are prepared to give deference to tribunals and to also take into account the workload of tribunals and the reason that tribunals are established in ascertaining whether reasons are adequate. And the other view about reasons is this, that reasons may be no more than a signpost to imperfect decision making. That is, you don't have an error of law by reason of the fact that the reasons aren't well expressed, but what you have is a document that enables you, by analysis, to discern a different type of error, such as a failure to take into account a relevant consideration. That's the view expressed by Justice Bongiorno in that case, cited on the left-hand side of the table, state trustees and the TAC. However, there is some good Court of Appeal authority, particularly coming out of the serious injury determination appeals, that suggests that if reasons don't permit a disappointed litigant to know the reasons why their case was dismissed and to bring an appeal against that case, then the reasons will be defective or inadequate as a matter of law, and that's something that can be taken on appeal. That seems to me to be a pretty subjective, evaluative task, and may indeed be a way of shortcutting the need to identify a specific error of law in the tribunal's reasons. Finally, and perhaps most directly, you can establish an error of law if it's shown that the tribunal had no jurisdiction. That is, that a precondition, a factual precondition to the exercise of jurisdiction wasn't present, or what might be termed a jurisdictional fact, or that simply the tribunal embarked upon a matter that exceeded the jurisdiction that it had to hear. So when you're looking for errors of law, you'd look at the reasons, first and foremost, back at the transcript of the hearing and all the submissions made in writing and orally, and at the materials that were provided to the tribunal. But you'd also look very closely at the statutes conferring on the tribunal its power to adjudicate the dispute, because it's going to be by an evaluation of those different sources that you establish whether jurisdictional error has occurred. Finally, it's worth drawing your attention to a number of three matters where in VCAT you have an automatic deemed question of law. They're listed in paragraph 36, but one of them, an important one, is the determination by VCAT of a strikeout or summary dismissal proceeding, where it appears you have an automatic appeal to the Supreme Court by reason of that deemed question of law.
Thank you all for coming. If you want to mingle quietly afterwards, please feel free. Otherwise, see you at the next Greens List presentation. Good morning.